Mr. Hankins?
Hi.
Mr. Hankins, how are you?
How are you?
Real well, thank you for asking. Miss Janelle, good morning. How are you today?
There's my card.
All right.
Sorry, I only brought one.
That's
Janelle, is it okay to call you Janelle, or would you like to be called Miss Llorens? Okay. Really wanted to appreciate you guys coming in this morning. Mr. Hankins, thank you for all that you've done as well in helping to coordinate this through Dave Harris.
I'm certain that it's to my client's benefit.
I believe it is,
Yeah.
and I think that you've acted appropriately, and I think Ms. Llorens understands that as well. And I know that you had asked for, and hopefully you had received a copy of the
Yes.
contract, and
Yes.
hopefully you've had an opportunity to discuss this with your client.
Yes.
Ms. Janelle, this is the original contract. I think Mr. Hankins showed you the draft copy that actually had draft on it.
Okay.
This is the original. I'd like you to have a chance to look this over with your attorney, and he probably brought the draft copy.
I did.
But feel free to go back and forth to make sure that nothing has changed with the exception of the draft being removed from the original contract.
Yeah, it's definitely not going to sign anything without reading it.
That's correct. Especially in a case like this.
And please, anything, if you want to ask me, ask me. And if you feel you need to go out in the hall,
Yes.
you can do that too.
And I've been through this before, so.
And at any time, just as Mr. Hankins said, that you guys want a break, the door is right there. Just step out into the hallway. There's a bathroom right down to the end of the hallway to the left. There's a drinking faucet right there in the front of control.
Good.
At any time, you guys can just feel free to say, hey, we want to discuss this on our own. We'll come back in and talk with you guys. Feel free to do that. At any time you want a break, just walk out, raise your hand, yell, whatever you want to do.
Okay.
We're really flexible this morning. We just appreciate you guys coming in.
Yeah, it's,
There is one thing I did want to tell you, Ms. Janelle, while you're reading that contract, is that, and I kind of got off track here in thanking you guys for coming in, but I think it takes a great amount of fortitude and integrity on your part to come in and want to resolve this case.
Yes.
Well, I wanted to resolve it since it was a federal level, so unfortunately, I didn't think that I was going to get wrapped up in all of it.
Well, we appreciate you wanting to do the right thing. And you're probably going to hear that AJ and Frank Carson and those guys are probably going to say that you're just coming in because you want to take a deal, but we don't believe that. We believe that you're coming in because it's the right thing to do. That you're acknowledging that there were practices that were occurring at AJ bail bonds that were not being done lawfully, and that were not being done ethically within this county. And you're seeing you saw the repercussions that it had upon our criminal justice system, upon the citizens that live here in this county, and you're wanting to resolve it because it's the right thing to do. So that's what we believe. So you're going to hear the twist of it from their counsel and from Mark Davis and or AJ, but we don't believe you're in here just to try to squirm out of getting a deal, being untruthful, to play games with your attorney, and to play games with us. We believe it's the right thing to do, and that's the way we believe it.
Well, I've been truthful since the beginning, and I'm sure both of you know that, so I'm ready to be done.
And Mr. Hankins, how long are you going to be continuing to practice law around here? And I'm not trying to comment that you're an old man here, but you've been around for quite some time.
It's starting to catch up with me,
Is
to
it?
be honest with you. I'm thinking I'll be 65 next June. I'm thinking I might pull the plug there.
Sometime then.
So,
I'm the same way. I'm not your senior, but these cases just
yeah.
And this is restitution in reference to this, what they're saying here?
Yes, that's repayment.
These cases just drag on and on and on, and sometimes the whole, and now things have changed with AB 109 and the court systems, and how flooded we are with the cases. And long gone are the days where you could actually kind of, get a case, work it from start to finish, have a completed case, and push it through the system. Now we're putting Band-Aids on it, we pass it to the next guy, he puts a Band-Aid on it, and we run it through the system, and it's not fair to anybody.
Yeah, honestly, I haven't been aware of that. I had a notice come across my computer from the County Bar Association regarding a seminar in, today's the 20th.
Yes.
Okay. But honestly, I didn't sign up for it. Okay, no. I love the work, I really do, it's interesting.
Since this case started, I have changed my married name, so my
You
name
can
on my
put
DSW.
AKA if you like, or you
I
can
just want to
put-
make sure there's not going to be problems.
No problem.
Yeah.
Okay, that's fine. Yeah, because I've just been signing Ms. Llorens.
I'll go ahead and witness that.
If there's anything else, feel free
Okay.
to
I didn't
use
come
that
prepared.
one.
Before we get started, Janelle, can I just get your updated address and phone number?
It's 2305 Glendale Avenue,
How do you spell that?
Glendale Ave in Modesto, and it's 95354. And my phone number is still the same, it's the 209-338-8025.
Okay.
And I just wanted to go through this with you initially before we begin the debrief or the process here of what this contract actually says. I know that you've had a chance to read it. You're a very smart gal. You're able to articulate a lot of information. I've interviewed you before in the past. I know Mr. Hankins is very competent as well. But what this contract is basically saying is that today begins a process, and I know you said earlier that you've been honest from the very get-go on this, but today is actually a day in which you've signed a contract that you're agreeing to make a full and complete and truthful disclosure of any and all information that you have pertaining to the crimes that were alleged and charged in this case, that you agree to make yourself available as a witness in each of the co-defendants' cases at such a time and place as may be necessary, and that you agree to testify fully, fairly, and truthfully at all hearings, trials, or retrials as necessary. That means that what we're asking for is the complete truth.
Understand?
We don't want you to word or say anything that is not truthful, whether it's for the prosecution or whether it's against AJ Pontillo.
Understood.
We have a case to do. We're currently in the process of going forward on AJ. And although we're looking for any and all information that pertains to that investigation, we do not want you to lie on the man.
Understood.
And or Mark Davis, because we have an active case going with Mark Davis. So the truth is the truth.
Yes.
And let it just be the truth and nothing but the truth.
Understood.
In the way that this is worded, that the Chief Deputy DA worded this, is that the actual truthfulness of your testimony is going to be made by the judge. The judge is going to determine whether or not you were truthful and honest and forthcoming at the time that you testify. If the judge feels as if you have been truthful, honest, forthright, that the terms of this contract then become cemented and are enforceable there, that you will get what has been mentioned here by Deputy DA Dave Harris as to count 2,
Plead guilty to
plead
count
guilty
2.
with sentencing continued until after your testimony is no longer needed, and that the prosecution will stipulate to a sentence of felony probation for 3 years with the standard terms and conditions. You'll pay restitution. You'll receive no more than 180 days in jail. My partner and I fully believe that if you do in fact testify truthfully, that if you're truthful from this point forward with this debriefing, that we will probably never see you again in the criminal justice system. We will likely never see you even within probation, with any probation violations or anything else like that. It is our belief that you truly want to put this case behind you, that you want to move on from this point, that there will not be any more reoccurring violations of this nature, and or I would venture to say that you're done with all this and the association with people that will likely put you in this situation, and we'll never see you again. So we feel comfortable offering you the terms of this contract as Mr. Hankins stated with Dave Harris Mr. Angus, do you want to add anything to that? I just wanted to kind of briefly go over that, just to kind
No,
of
I
set the
believe
ground
in
rules
rules of
and
faith. You know, I wouldn't lead you guys on. And we've talked about some of her future plans, and I think that this agreement could help benefit her in her future plans, in her life.
most definitely.
She's just basically being a mom, so I just want to move on from all this.
We understand that.
That's important.
Now, Investigator John Renucius with the Department of Insurance, he had a bulk of the investigation regarding the various bonds, the forfeitures, the exonerations. As you know, I dealt with the Gonzalo Lopez matter, the whole prior notice, prior consent issue. I'll talk with you briefly about that. But I'm going to turn everything over to John to let John start asking questions regarding your prior statements or inconsistencies that we may have noticed between your prior statements and or information pertaining to those forfeiture matters.
Okay. Just before we get started, the room is being recorded.
Okay.
My goal was to not have a big long piece of paper to hand over, so it's just going to be recorded. I might take a few notes, I might not. He might take a few. Is there anything before we get started that you'd like to say?
Not really.
Okay.
Well, we're happy to have you this morning.
Thank you.
Yes.
I'll reiterate that.
Just kind of tell us how you met AJ.
I was working at the gym, which was Gold's Gym at the beginning, then it transferred to some other gym that Fred named it. But basically I worked for Fred Stevens at his gym, daycare. Then shortly after meeting AJ, just through being a member at the gym, he asked if I wanted to watch his children. I babysat his children for a little bit off and on for a while. We had a little bit of falling out because I couldn't show up for work one day. So he had somebody else. A few months, I don't know exactly how much time, but some time lapsed, and then I ended up coming back working for him, babysitting 2 days a week. I stopped working at the gym. I babysat till I was, I think, about 18 or 19 when I started. Maybe somewhere in there is when he offered me to come to the office, and basically it was just to come clean up. The office was, in disarray. Agents that weren't picking up after themselves, common sense stuff. So he brought me in just to kind of help out. I took notes at meetings. Didn't really have any stand in the business, was just kind of the sidekick, I guess, for lack of better terms.
Okay.
Some time went by, and I'm sorry that I don't know exact amounts of time. It's been a while.
That's fine.
Time went by, and I got promoted to basically the office manager. It was just the title. I just had to make sure that everybody's doing what they were supposed to do within regards to turning in their paperwork and that things were filled out properly and whatnot. Shortly after I was office manager, Josefina Munguia, came in. She was also office manager alongside with me. The goal was to kind of have an office manager there at all times, just to make sure that things were going smoothly. And that's pretty much.
Now, did you take over for an office manager?
When I first started working there was a girl there. Her name is slipping me. Not Ashley. Maybe it was Ashley. I want to say Ashley Chestinator. For some reason, she was working there. And then like a few days after I started, she just didn't show up. And then AJ told her, well, then don't come back. I don't need you. So that was the transition between somebody else being there prior to me being there.
Okay.
So he elevated you into an office manager position within the business, and you were the only office manager at that period of time within AJ's?
Mm-hmm.
And at some point, that was a comment made by AJ Pontillo. He says that, and this was written in 2010, he says that he's actually only had 2 right-hand people that he considers to be very close to him in this business. One is a person by the name of Jason.
Which is his brother. Is his brother. They don't talk anymore, but it's his brother. They have the same mom.
And then I'm assuming Janelle L. is you.
Yes, sir, that's correct.
Jason's last name is?
Delphinus.
Okay.
So he basically said that, and elevated you into the status of being his current right-hand man, is what he says down here. And he elevates you into the status of almost being family with his brother.
Well, I'm not family with his brother so much, but since, like I said, I spent so much time with his kids, I've been a part of his kids' lives forever, even currently, so as far as family goes, that's why he considered me family, because I had such close ties with his children.
Okay, that's fair to say. Go ahead, John.
Yvonne, what's your relationship, or what was your relationship with Yvonne?
I would consider her almost like a sister to me. We were really close. I mean, like I said, there was a stint when they moved out to Albers that I was live-in nanny with them. I resided at the residence for, I believe, 2 years. So, I mean, you know, I was family. Me and my husband, who is my husband now, he was my fiance at the time. We lived there. You know, we were a part of the family. The daily goings on, the family trips. You know, we were really close.
Did anybody at the business have that relationship with AJ, other than you?
Not that I know of, like, that they were as close as I was, but AJ, I mean, always opened his home to his employees. I mean, we had swim parties, birthday parties. Yvonne was the party queen, you know, so birthday parties, Halloween parties for the kids, and the employees were always invited.
Okay. Now, are you related at all to Yvonne?
No, there's no blood relation between me and
Okay,
anyone.
okay,
Yeah.
okay, so you guys were just real tight?
Yes,
friends.
I'm an only child, so I have no
Okay,
siblings.
okay. And now, so you lived with AJ for about 2 years?
Yes.
While you were basically a nanny for him?
Yes, sir.
Okay. How did you meet Mark Davis?
Through AJ's bail bonds, he was AJ's motion guy. He was the motion go-to. As far as I knew, AJ didn't know anything about motions. We just, you know, tried to make sure that people were back in custody when they needed to be, and that people didn't miss court, and tried not to let it get to the motion point. And when it got to motions, Mark Davis was the one that the files went to, or the copies of the files went to, so that he could handle the motions. I knew nothing about motions. I mean, being in the business, I barely knew how to write a bail bond in the beginning. You know, I mean, I got my license just because I worked there. And AJ just trusted him. He was the go-to guy. If motions needed to be done, they got given to Mark, and whether it be time extension or exoneration or whatever Mark thought needed to happen, he was the guy who knew how to read the paperwork and knew how to look for what he was looking for and what motion needed to be done. And I was just the one in the position to sign it and send it back to Mark.
When you're saying that he would get the paperwork and he would have an opportunity to review this, were you also the one that was responsible for making copies of the files to get the files to Mark Davis?
At times, but I was not the only one that held that responsibility. There were other people that rotated through the forfeiture department that I would tell them, you know, these files need to go to Mark Davis, and they would copy them. Sometimes I would make sure that they were copied, and other times I wouldn't. You know, there were a lot of people working there, and there was a lot of trust that everybody was doing what they were supposed to do.
But you're confident that Mark Davis would have the necessary information he would have from the files to be able to write these motions?
Absolutely. Anything we had in our office, Mark received. And there were times when Mark came into the office and went through files when he wasn't supposed to. So, I mean, Mark had access whether or not we were letting him have it. So
he could come in on his own?
Yeah, and there were multiple times when he came in when there was no office manager, you know, it was just the agent there, and, you know, he would go in and just have his way. You know, AJ wasn't there was nobody there to stop him. And yeah, there were multiple times when Mark had access to files, and I know that there was probably documentations in employee files or in memos that were taken about coming in and touching files when you're not allowed to. And the forfeiture files actually ended up in a cabinet that had a lock in it so that wouldn't happen.
Okay.
Did Mark have a key to that?
No.
Okay. At some point, when did that lock get put on?
It was after we got new office furniture, but then again, you know, it was up to the responsibility of the person's desk that it was at to make sure that it was locked every night.
So Mark could always talk to that person, he could get the key, he could also have access to bond tracker, the notes in the computer systems?
I would say he absolutely could, because if I wasn't there and AJ was there, then, you know, who's there to stop him? You know?
So the whole premise of Mark coming in and saying, Janelle never gave me this information, or I never received this information, is completely erroneous.
That's not true. Even if by some slim chance I didn't give him something, there was no reason why I couldn't be contacted to give it to him. He had access. I answered my phone 24/7. That was one of the mandatory things for my job, is that my phone had to be on 24/7. There was no reason that I couldn't be contacted or that he couldn't come into the office and get what he needed from somebody. And unless he was looking for something that he didn't necessarily need, there was no reason to keep anything from him.
Okay. Understood. And if I understood what you told me previously, when we're talking about Mark Davis, you weren't the individual that was responsible for paying him for the motions that he was writing for the business. You weren't the one that was responsible for working out his contractual agreement with the company that was
absolutely
That was
not.
AJ's responsibility as the owner of the business?
Yeah, my only responsibility when it came to the motions was making sure that the forfeiture files got given to Mark and making sure that, and being the one that had to sign it when, he was running out the door to go file it at the
Right.
courthouse. But I never, as I can recall, I never filed any of the motions that Mark produced. Mark personally handled that. The only thing I ever touched a motion was to put my name on it, and that was it. Then Mark took it wherever it went from there and talked to whoever he needed to talk to from there.
Okay.
Okay, for Mark, did he had a key to the business? And did
No, he didn't have a key to the business, but there was somebody at the business 24/7.
Okay,
There was
so-
always somebody there, so the door could be opened at any time, yeah.
Okay.
And
Now-
he was well-known and trusted by all the employees. with-
Everybody knew him, and everybody knew that he wasn't supposed to be coming in and getting into stuff, but that didn't always stop him. And as I'm sure you've heard from other employees, there were times when he came in and kind of, was just a pushover, like, oh, AJ said I could, or whatever needed to be said, so that he could have access. And then, come the next day, it was Mark Davis was here, and, he was copying this and copying that, and, and after it's done, what's there to do?
But
And,
the point's made is that he could have done that on each and every case.
He could have. He had access to the, he had access to the files, and why would I want to keep anything from a file that I need him to be able to do a motion on?
That's what we're asking.
And then, and then to top it off, he also had access to courthouse files, so there was no reason for anything to be missing, or, and if he didn't have something, then that was at his fault.
Sure.
And there were numerous times when I had him sign that he received a file, because after this was happening, I was starting to get reprimanded for, Mark said you didn't give him the file.
Right.
And then I came up with my own system to have Mark sign that he received a file.
Right, and it'd be something similar to that. You'd keep a note on the file that you'd make.
And then there were some stamps where, we were actually stamping on the file, Mark Davis signed that you received this file.
Right.
That way he couldn't tell AJ a month later when, we're getting the summary judgment that, oh, never gave me the file.
Right.
So,
And as part of your duties, you kept track of that. You also made entries or had your staff make entries into the bond tracker
the
systems.
best that I could, I
Okay.
really tried to make sure that everything was documented so that nothing could be said that wasn't true.
Okay.
Did Mark have access to Bond Tracker?
I don't see why not. I mean, the computers, once Bond Tracker was logged on, it was logged on, and it didn't even have a password until after our first crash, which had to be like a year or two after I started working there. So even the password, once somebody was logged on, we didn't log out of our computers when we stepped out to lunch or whatever, so there was no reason that he couldn't have came in and clicked on it. And I know there was an instance where he had went on one of the employees' computers and went onto his Facebook through the computer and changed stuff. And so, I don't have any reason to believe that he couldn't access it.
But not only are we talking about access to the bond tracker on the computer systems, but oftentimes there were sheets that were printed out from the bond tracker that were actually included in the file itself, like this, correct?
Correct?
So even if he, say, for instance, didn't know if there was a password or know how to get onto the computer, that oftentimes, when you're providing him with these files, there's actually copies of the actual bond tracker notes included
The
in the file.
bond tracker notes were part of what was required to give to Mark Davis.
Thank you.
Okay, as far as Mark, so he just kind of came and went as he wanted at
Yes.
the business. And was he already employed there when you started?
The best of my understanding is that Mark was never technically employed with us. He was just an independent contractor that came in to do the motions. And there were instances when he assisted David and them when they would go out looking for people. But he was never an employee where, he would come in and write bonds on a certain, what I would consider an employee, the people that came in every day that had a task to perform every day. No, he wasn't like that. He came and went as he pleased, and the only time he really came around is when we needed motions done. Other than that, he wasn't somebody that we wanted around the business.
Why is that?
Just because he was Mark. He just had a bad reputation. Not a lot of people liked him, and AJ had fallings out with him, but he was the motion guy, and who questions somebody who's been doing this their whole life?
When you said he was didn't mean to cut you off there. When you said he was an independent contractor and he was the motion guy, he's the kind of the guru of doing the motions for the bail bond business. Do you know what other bail bond companies used him besides AJ's?
As best that I know that he had done motions for Joanna's, and I want to say Garcia, but the only one I know for sure is I know that I had heard him talking about doing motions for Joanna. So that's the only one that I can say for sure that I've heard that he's done the motions for.
And just so that Mr. Hankins knows, in case he hasn't had a chance to review Mark Davis as part of this investigation, Mark Davis is not a lawyer.
Oh, yeah.
He is somebody who perhaps people may view as being someone who is not practicing law without a valid license, a law license here within the county. Is that correct? You don't know him to be a lawyer?
No, I don't know. I never assumed that he was a lawyer.
Is he a private investigator? Is he licensed to be a private investigator at all? Do you know that?
Not that I know of, no.
And do you know him to be a bail agent?
Yes, he was a bail agent as far as I knew. He was a bail agent, and that's why he could do the motions and file the motions. Mark didn't like me, and there were a lot of complaints made, and AJ had told him time and time again, well, instead of complaining about, why don't you teach her what you know, and then she can help you. But that was something that Mark never felt to do, just lots and lots of complaining about how I didn't know how to do my job, which, of course, I'm not the motion person. I don't know anything about that. I know how to write a bond, post it at the jail, and, call them and remind them of their court date.
Right.
That was the extent of, what I was taught. And then, just the basic business. Being the office manager wasn't that I knew everything about bail bonds. It was that, I knew how to communicate with people, and a lot of it was take the garbage out after yourself and don't leave your tuna in the sink.
Right.
And a lot of it was a lot of stupid stuff,
Right.
So, even though I had that position didn't mean I was necessarily the smartest person in the business, just somebody that AJ trusted, so.
Okay, I understand that. With Mark not being a lawyer who's allowed by law to practice law within the courtroom to represent a corporation or a surety or whatever the case may be, was there a staff or a law firm that AJ would commonly go to when, for instance, he needed legal assistance in court?
As far as I understood, Mark could represent the motions because he was an agent that was appointed through accredited, which was our bonding agency.
Okay.
That was my understanding. I don't know of any times that we actually hired an attorney because of motion, except for when there were problems with Mark Davis and AJ had motions done by Bernstein, I want to say.
Bernstein, Fresno.
Yeah, and that was the case where, and we did the same thing. We sent them the whole file, told them what the situation was, we needed the time extension, and then they would produce everything at their office, send it over for signatures, and then those were the only motions that I had to physically take and file because obviously Bernstein's not going to drive all the way down here just to file the motion.
Exactly. And you also understand that with Bernstein and what was the other person there with him? Rohrbach. That they're professional lawyers.
Yes.
There's costs associated with hiring and retaining Bernstein and Rohrbach. And for instance, I think it's fairly common amongst the bail bond industry that usually motions run anywhere between kind of a starting price of being about $1,500.
I think it depends on the amount of the bond, is my understanding. It was a percentage depending on the amount of the bond, I believe is what it.
And what was the normal or the average prices on that? If say the average bond in Stanislaus County being about $20,000.
I'm not sure, but I want to say that they charged, it was like a 10% of the premium. But I think it also depended on what the motion was, like if they were motion for exoneration or if it was a time extension. But in each case, like with Bernstein, we would call, tell him what we needed, and then he would, call back with the price for the motion, and that's how it worked. But as far as Mark goes, I have no idea how that worked. I know that we even had problems where he wasn't sending AJ anything to say, like, this is how much you owe per motion.
Right.
So I know that at one time I had to actually produce a statement for Mark, like, is this what you think we owe you? So I don't even know how that worked. I don't know how Mark got paid or what the situation was with that.
And why is that?
It really wasn't my place.
So AJ wouldn't tell you what he was paying Mark Davis, or?
I really had no concern with it, honestly. I mean, with everything else going on in the business, what Mark Davis was getting paid was really the least of my concerns.
That was between him and AJ?
Yeah, that would be something that you'd have to definitely discuss with AJ. I'm not quite sure how that worked.
But if AJ told me that he was giving Mark Davis $400 a motion, and that included all the filing fees and everything like that, for these motions to exonerate the forfeitures, to extend time, or whatever he needed Mark Davis to do, would that figure be something that you might remember him talking about, $400?
I honestly, they never, it was never anything that was discussed in front of me. The extent of me and the motions was give Mark the file, tell him I want the time extension, and make sure he does it. And that was it. The next time I heard about that motion would be to sign it and then to find out if it went through or not. As far as he got paid, I'm not even sure, you know, I mean, of course, you know, I did some of the accounting, like make sure the bills got paid and stuff,
Right.
so, I mean, I may have glanced at it at some time, but I can't quote you an amount and tell you for sure, like, I know that he got this much for this motion, or that much for this motion.
But I think we can probably reasonably conclude that Mark Davis would be a lot cheaper to hire than Bernstein and Rogal.
I mean, I'm not sure, you could assume, but then I'm not sure. I can't say, because I don't know. I know at one point he received a Corvette as payment, so, I mean, I don't know how much cheaper that is.
Davis did?
Yes.
At what point was that?
That was, not last year. Had to be a couple of years ago, but I know that,
Before the arrest?
no, not for arrest, but for.
No, before your arrest.
Oh, yes, definitely before. It was before the arrest. You know, AJ turned it over to him as payment, so, and it was on his taxes, because I know when we sent him his tax form that was something that I had to be added, you know, whatever the monetary value of that was, so.
Do you remember the monetary value?
I just remember that we had to call the accountant and tell him to add the Corvette to Mark Davis's W-2. I think that's the one he gave me.
Do you remember the year of the vehicle?
No, I just know it was a yellow Corvette with yellow rims.
Was it like an older Corvette or a newer Corvette?
I didn't know.
I was just gonna follow up on that.
Okay, go ahead.
AJ actually told me that he paid Mark Davis $400 per motion, and the $400 fee was all inclusive, including the filing fees and the things that he needed done. And I think it's safe to say that with 10% of the premium being part of the contractual agreement that Bernstein and Rohrbaugh wanted.
Which I may be incorrect. I know that that's in my mind, but it either pertained to the motions, or it may have been like the recovery fee for a skip. I don't want to.
Right, I understand.
Yeah, I just remember that that's in my mind as something that was paid. So I may be wrong in paying for motions. That may have been like the recovery fee. Like once we had a skip, that's what the recovery fee was. If we had to hire an investigator to pick up the skip.
Okay. And in the previous statement that you made to me, you said, quote, I gave him, being Davis, the summary judgment and the minute orders that were with it. And this note was actually on the summary judgment, the one that I showed you. And this note was intended for AJ to read so that he would, because I know when he, AJ, gets summary judgments, it doesn't make him very happy. So I was just confirming with him, I was already seeing what I could do to remedy that situation. So with you saying that, it's safe to say that AJ was pretty meticulous as to how he wanted his business run, and he wasn't very pleased or happy when he got these forfeitures.
It wasn't the forfeiture so much, because of course we're going to get forfeitures when
Right.
you're writing that
With the
many
summary
more.
judgments.
With the summary judgments, as would any business. I
Right.
mean, a summary judgment pretty much chalked up to the person missed court, nobody ever found him, and how come we never filed a motion for time extension? That's what a summary judgment would chalk up to, which would leave me in the position of, did I just not notice this file? Was it really my fault? Did it get given to Mark Davis and he just didn't do anything with it? So that's why, of course, he'd be unhappy, because at that point, he should have known that the summary judgment was coming, if it was something that, we've done everything we possibly can and the summary judgment's just coming in, we gotta pay it, which has happened, and that's not a big deal. But getting a summary judgment because, we failed
When
to
you're
do
saying it's
it
not
in
a
between
big deal,
steps.
there was a period of time where there were not a lot of payments being made for summary judgments, especially for a business the size of AJ's that was doing the amount of bail that they were doing.
Okay.
Why is that?
Was it because we weren't getting summary judgments? I'm not clear on your question. Are you
The-
saying that we
the-
were getting them but we weren't paying them, or that we just weren't getting them in general?
I'm saying that the actual amount of being paid into summary judgments, when you're looking at like a spreadsheet of what companies were writing a percentage amount of bail versus AJ's writing a higher percentage of bail and yet having a lower amount of summary judgments, is that because the office staff is just so effective in
I would say
and
so.
looking for
We
these
had-
flaws or these
Yeah, we
legal
had-
technicalities to get out of these
Not to get out of them,
or-
but I think that they just weren't necessarily going to summary judgment as much. We were writing a lot of bail, but we had a full staff. I mean, we had people that were calling and reminding people to go to court. We had people that were available if you needed a ride to court. We were doing everything we could to make sure these people were in court. We were at the courthouse making sure that they were
You
there.
had court checkers.
Yeah, we did everything that we possibly could to make sure that they held up their contractual deal, which was to be at court. It's not to miss court. And once they missed court, we had people that were working, to make sure they were there. We did address checks to make sure that we knew where they were going to be if they missed court.
And there were notes made on bond tracker.
Yeah, we did a lot of...
Files were reviewed, information was put into the files.
Mm-hmm.
Files were provided to the appropriate people to write these motions.
It was a madhouse. We had a ton of people working there, and there was a lot of trust that each little department was doing what they needed to do. And for a long time, it worked. It worked out well. And then somewhere along the line, the summary judgments just started coming in, and a lot of that was, I put to Mark Davis because we would give him files, do a time extension. We don't need a technicality. We don't need any of that. Just do a time extension. We're looking for him. Then a month would go by, and then it's, well, how come we're up for summary judgment? Oh, well, because I just said just wait for the summary judgment. There's a technicality. And it was...
That would be Mark saying that to you.
And that's what Mark would say. And like I said before, who am I to question? I'm not going to be like, oh, you know what you're doing. I don't know.
But after a course of a period of time, you told me that you would actually give it to Mark Davis to see if there was any flaws. And you used the word flaws, and then also you used the word legal technicalities.
Mm-hmm.
So at some period of time, you knew that, hey, when it got close to either being at the end of the extension period, or if you did get these summary judgments, that it was an automatic to go to Mark Davis.
Well, of course, and of course I thought that he was doing it legally, if there was anything he could do to help the situation, I wasn't asking him to break the law, which, obviously it looks like he has, but, and there would have been nothing wrong if he would have gave the file back and said, no, there's nothing we can do, you're out of time. Then we would have had to deal with it accordingly. These choices to do these technicalities, those were Mark Davis's decisions, and unfortunately for me, I didn't have the common sense to question them. Just sign it and, do what you need to do, Mark, and thanks for helping us out.
Did you want to ask her any follow-up questions regarding that on any of the motions, or?
Janelle, the thing is I want to try to avoid showing you each motion and
Understood.
everything. And we could be here all day if I did that.
But what you're saying,
I've
okay, you've seen all, I'm sure Mr. Hankins has seen them too. What you're basically saying to us, Janelle, if I understand what you're saying correctly, is that the writing of these motions far exceeded your expertise in your position of where you were at within AJ bail bonds. And you were told by AJ, being the owner, that all of this information goes to Mark Davis because he is the one that has the contractual agreement with Mark Davis. You weren't the one that was telling Mark Davis what to do as to the amount that he would receive per motion. That all was handled by AJ.
Absolutely.
So when you would make files and you would have your conversations with Mark Davis, just as this note indicates, you would then alert AJ Pontillo as to what you were doing and what Mark was doing, so that AJ was apprised of what was happening with this particular case, because, just as you said, he's not very happy when he sees summary judgments. So you document the file, you provide it to Mark Davis has an ample opportunity to respond or do what he needs to do. You simply sign the declarations that are provided to you under your belief that Mark Davis is doing whatever he's doing, opposing whatever it is, in a legal manner.
That is absolutely correct.
You're not questioning Mark Davis when he asks you to sign these documents.
Absolutely
You're not confirming that the information in the motion is substantiated by the information in the bond tracker.
No.
You're not confirming that the information that's in the motion is corroborated by the statement of facts that you have within the file itself.
No. It frustrates me because now I see how stupid it was for me to do that, so excuse my attitude. But yeah, absolutely not. That's what happened. Mark would come in at the end of the day, hey, the courthouse is closing in 10 minutes, I need you to sign these, I need to get down there and, sign away and,
And you took him at his word because he was, one, a person of trust within the business. AJ trusted him exclusively.
As far as the motions
As
go.
far as the motions. and that he kind of had, even though you said he had a bad reputation, he did have a reputation of being a guru,
A motion guy.
a motion guy within the bail bond industry here within Stanislaus County.
That was my understanding. That's who Mark Davis was, as I knew him. I mean, I didn't know him personally as anything else. He was just a motion guy. He was the guy that did motions,
So it'd be somewhat similar to, for me in my position, is the chief deputy DA coming down and saying, hey, I need your signature on page 3. This is the declaration that you provided. I did some minor touch-ups in it, and the courthouse is closing. I'm going to get this filed by 3 p.m.
And I would sign it because it needed to get done.
No questions asked.
No questions asked, because in my head it's correct, and if I don't sign it and it doesn't get filed, then it's going to be my fault that it's not done.
But now that, as you said, and not to use your own words, but
Okay.
you felt stupid, now that you've had a chance to talk with your attorney to go through this paperwork, you have seen how you've kind of been used in this situation.
Yes, I have seen these motions that I have signed, and yeah, they're crazy. And I don't understand why a lot of that stuff is in the motion when, to me, it doesn't even seem necessary. I mean,
You know, going on that same point, you're not the only one. A.J. Pontillo told me during my interview with him, is that looking at a particular minute order, because, you know, as you said, this file contains a lot of various documents in it, drawing your attention to a particular minute order where a file is marked good cause not to forfeit bail on this Rigoberto Gonzalez Lopez case. Here we have Judge Cordova actually saying good cause not to forfeit the bail. He's actually checking the box, forfeiture set aside, bail reinstated. And then during the interview, you have A.J. Pontillo that says, unless the box was checked, good cause not to forfeit, then they reinstated it. After that, then this would be a different story. Oh yeah, I'm sorry, if they checked the box, good cause not to forfeit, then reinstated it, I wouldn't have a leg to stand on, period. And then he says, no, absolutely, can I understand? It says right in there. And if he had the notes, being Mark Davis, if Mark Davis had the notes, well, that would seem like a no-brainer at some point. But you know, I'm not Mark Davis. So he's saying the same thing that you're saying.
and ultimately, I mean, minute orders especially, even if Mark wants to say, I didn't provide that copy of the minute order, that's your responsibility to do your due diligence and make sure you have everything you need. And minute orders
But what about if it's in the file and you provided him with a copy of the file and he still writes this motion?
And that's what I'm saying, that then...
And AJ says this is a no-brainer, and you're saying, hey, he's the guru.
Yeah, why question, I mean, it's just like when you're a baby, when you're being taught to walk, you don't question why, you just do it because your parents know better than you, I mean, it just... That's really what it is. I got suckered. I put my name on a whole bunch of stuff that, now I'm being punished for. And it...
Well, I understand that, and I understand that the position that you're in. I do have, am I cutting into you here?
Go ahead.
Since I have this file open, I wanted to kind of speed this along.
Come back up.
We were talking about these bond tracker notes, and as Mr. Hankins, I'm going to bet you'd be able to look at these too as I'm going through here.
Thank you.
You'll see that, and this is what I need you to help explain to me, Janelle, because I'm trying to rationalize how certain notes are created in Bond Tracker and then how these notes are printed out and put in the file. But you'll see here where the original notes in Bond Tracker that you provided me, let me just use that. This is the evidence that I seized that particular day from you during that search warrant. And I think that's a sticky with your...
That's not my
That's not your
handwriting.
handwriting? Okay, maybe somebody else is within the office. But you'll notice on these bond tracker notes, this is straight from the computer. It says that, let me just get a particular date here. Kind of drawing your attention to this whole deal when we're talking about this lack of notice, or as Mark Davis would kind of confuse things, being a lack of consent for that reinstatement on that bond on Gonzalo Lopez. Remember when I went there to serve the warrant and got the file?
Okay.
It says right here, there's a series of entries into Bond Tracker with David Nelson. I'm assuming DN is David Nelson.
Yes, sir.
And JM is Josefina Maguna.
Yes.
You'll see that there's a series of entries here. I want you to look at this one here dated October 30th to 2008. It says, per Sam, defendant present. That's me and Gonzalo Lopez was in court with the initials of JM. Now, look at in the file, under that particular date, and look at this note here on the same date that's entered on 10/30/2008. It says, per Sam, defendant present, ... there's no JM now. Now there's an addition. David spoke with the defendant, JM. Per minute order, good cause, not to forfeit bail, bench warrant recalled, FTA set aside, reinstated. Defendant released on bail. New court date, updated AJ, and then JM. How do you reconcile that difference between what's in the file versus the notes in the bond tracker themselves? Why is this critical information deleted from this in the computer and being printed out and put in the file?
All I can say is that bond tracker wasn't a locked system. So it wasn't like you could, once you entered a note, it wasn't like nobody could go in and change it.
But what I'm saying, Janelle, is that somebody altered this information, filed a false and fictitious motion with our court when they knew very well that they had received the minute order. They noticed Judge Cordova had in fact wrote good cause not to forfeit bail, and even AJ Pontillo, the owner of the business, said if that was the case, this is a no-brainer and this should not have been done. Who did this?
Anybody who had bond tracker could go in and alter notes. That was a problem that we were having because bond tracker system itself didn't have a specific per person login. There was no way to lock notes that you couldn't go back and change stuff and update stuff or whatever needed to be done. So anybody who had access to bond tracker could have went in and added or deleted. Huh?
Did you do this?
Did I do this?
Did you delete that entry?
No, not that, no.
Did you ever delete any entries?
Stuff that was entered improperly, yes.
Okay, because there's several, out of the forfeitures that you've been charged with, when we went back and looked at stuff that was recovered from Mark Davis's residence, compared to what's in the claim file, compared to what's in bond tracker, they don't match.
Just like
There's
this.
missing.
There's entries
Just like
that do
this,
not
and I
match.
could go into a lot of detail, but I
Okay.
don't want to do it here. You know, I've got one example that I could show you.
Okay.
But there's several missing entries, and they're all key entries. They're not stuff like, you know,
Like mistypes and whatnot.
right. They're received forfeiture letters.
And somebody having
Boom, that's gone.
Right. Somebody having this information in a bond tracker, in a file that's given to them the right emotion, and they actually see this in bond tracker, wouldn't that be a red flag to go, oh, we don't have a leg to stand on for this reinstatement?
I would assume.
Just as the owner himself said, ooh,
Yeah, I mean, I would
this is
assume.
a no-brainer.
Yeah, I mean, and like I said, you know, anybody who had access to bond tracker could go in and, you know,
Does
add
AJ
notes.
have access to bond tracker?
Yeah, he didn't use it most of the time. That wasn't really his forte. But I mean, yeah, he could have gone onto a computer.
Did
That's
Mark
possible.
Davis have access to bond tracker?
Yeah, he could have got on the computers. Like I stated earlier, he had issues with hacking into employees' computers before. So yeah, I would say he could.
If, let's say, for instance, in this particular case, that this went to summary judgment and it was paid out, who is going to be financially responsible for that summary judgment to the county? Are you going to be financially responsible for it? Are you
No.
going to get docked out of your paycheck?
No.
Are you going to be disciplined in some form or manner with summary judgments?
I might get talked to, but there wasn't like I was going to lose my job or lose pay. There was no financial loss or gain when it came to motions and me. I mean, it was my job to make sure that, you know, people got what they needed to get and that stuff got done. But if, God forbid, something went to summary judgment, absolutely not. AJ didn't come to me and go, you know, you owe me this
You're being
much.
docked,
No, no.
2 months pay for this
No,
one?
I might get a discussion, like, you know, you need to pay attention and not let this happen again, and, you know, make sure you give stuff to Mark because he's saying you're not, you know, like that kind of reprimanding, but absolutely nothing financial.
Did you ever overhear any conversations between AJ and Mark regarding his success or the lack of progress therein with his ability to get these exonerations?
As in regards to whose
Like
success, I'm not understanding your
either
question.
Mark Davis's success with his motions, with AJ's motions in the courthouse.
I know that, I mean, Mark pretty much just lived off of doing motions. I mean, for bail bond company, and like I said, you know, we weren't the only ones.
Right.
So, you know, that's pretty much it. And, you know, I never really heard Mark writing a lot of bail, so I have to assume that that's what his key source of income was.
And so what you're saying is that basically Mark's sole source of income that you know of, as being a guru of these motions within the county, were to provide these types of services for AJs and other bail bond companies to write these types of motions.
That would be a truthful statement. I would have to assume that. I mean,
And his reputation would have to be
he
one.
certainly wasn't writing bonds like any other bail company in Modesto. You know,
Right.
It wasn't like his normal forte. And this is pretty much, for the most part, what I remember Mark doing. He wrote motions. You know, he was one of those people that were just really into, looking at
Right.
court stuff and knowing who's in custody.
Did you know if Mark had any particular help within the courthouse in helping him secure information that he needed?
I know he had relatives that worked at the courthouse, but I mean, I can't say that they supplied him information. That wouldn't be something that I could state truthfully that I know for sure. I know that he has relatives that work at the
And
courthouse.
so you don't know if any of those relatives that work at the courthouse ever provided him with maybe special favors?
I don't know personally. I don't.
Have you heard talk or conversation with
Of
that?
course, there's rumors, that
Within the business itself, within AJ's?
not necessarily just within the business, but within the bail bond industry. I know that we used to have our meetings.
Your bail bond meetings, yeah.
Yeah.
What
And
type
I
of
know-
information would surface
I
regarding
mean,
that?
there was gossip that Mark had help, or that his family was helping him out with files in the courthouse, but that's not something that I can say that
Right.
I've personally seen or witnessed, or that I've heard come from Mark's mouth.
Right, and we took a look at that too, to be honest with you, Janelle. We took a look at that and we actually saw where the court was sending these forfeiture notices, whereas if Mark did have a lot of inside help, you would think that the court would be losing these forfeiture notices being sent to AJs. But we actually noticed that many of those notices were in fact getting sent to AJs. You guys actually received the notices, you actually opened them up, you saved the actual envelope with the file stamped copy of the postmark date on the outside. But then, as you stated, Mark likely used you to file declarations to say that you had no notice of these forfeitures coming
Now, when
into
it comes
business.
to that, my understanding with those motions that he was doing about the forfeiture letter was that he wasn't saying that we didn't get the forfeiture letter, because, I have the forfeiture letter, why would I sign something that says I didn't get it? But he told me that the
This is
motion...
Mark talking to
Yeah,
you.
the motion
Yeah.
was because they didn't sign it. And since it wasn't signed properly, it wasn't valid.
So the court didn't sign
The
the
forfeiture
forfeiture
letter
letter being sent to
properly.
AJs, okay.
And
that's what Mark
because it
Davis is
wasn't
telling
signed
me.
properly, then it wasn't valid. And that's what he said his motion was standing on.
And did you actually look to see within the motion that you were signing whether Mark was arguing it and articulating that to the magistrate?
No, I didn't.
So you were just taking Mark at his word that,
Yes.
whatever it was.
Yes.
But Mark was telling you that that was the reason why he was making that declaration.
Yeah, that was how I understood it, yeah.
Okay.
And I'm sure that I used a more technical since last time you asked me that question, but it's been a while since I've been in the bail bond business. But yeah, that was the understanding.
If you don't mind, what are you doing now?
I am a stay-at-home mom, and I work one night a week at a video store.
That's a full-time job in and of
Yes,
itself.
and
Take care of kids.
that's all I want to do with my life, and I want
This to be over with.
to be done with this. And of course, I want everything to come out fairly, and if this is what I need to do so that everybody can
We appreciate
get
you
their
being
justice,
truthful.
then that's what I need to do.
We appreciate you wanting to be truthful and wanting to be forthright with this
Well, absolutely,
information.
absolutely.
You obviously understand from our perspective, all right, this is, as much as these people want to try to make this personal with us, you do understand that county council and I were diligently searching to rectify the problem in this bail bond business, right?
To some extent, I do feel that maybe there was some tension between AJ and some of the investigators and whatnot, but you guys do what you need to do, I guess, who am I to say what anybody's job is, so.
Do you understand that county council and I were simply trying to make the bail bond industry follow the law here in this county?
I understand
Right.
that, yeah.
And when you're seeing this type of stuff with discrepancies between what the notes are that we're seizing on search warrants and notes that are different in the files that are not matching with information that the court is receiving, you understand there's a problem.
I can see how that could be odd, yes, I can understand.
And it's, okay, Sergeant.
Okay, getting back to the motions that you're charged with.
Okay, which I don't know off the top of my head, but I know that there's a lot of them.
Okay, they range from Taft Tenant
Okay,
to, that's a name you're...
I remember that name.
Okay, yeah. In the case of Taft Tenant, there was an original motion filed,
Okay,
okay? And that was filed by Mark on 1/30 of '08.
okay,
And I'm just gonna go through kind of the
Just kind of
timeline.
refresh me there, okay.
Timeline on it, okay. Then on 5/8 of '08, Mark files 4 additional motions saying that no forfeiture letters were ever mailed. So you got one case that goes through in January, and then 4 additional that go through, along with, I think Beltran was another, Tammy Reyes Beltran.
I'm so bad with the names right now, okay.
Have you read all the discovery?
I've read it, I mean, not recently, I mean,
okay.
this case has been going on for a while, so.
Right. So basically, on the first motion, Mark files a motion saying, we're looking for TAF,
Time extension.
time extension. I need a time extension. On the next 4, it's at the point where I think it's already after summary judgment on the next 4. And basically he files a motion saying that the forfeiture letters were never mailed on 5/8 of '08. And then on 5/28 of '08, he files a second motion for the first case saying that we need more time because we're still looking for him. But then on 6/24 of '08, you filed a declaration stating that you did not learn of the forfeiture until, and what you have is 5/29 of '08. I actually think that it's probably 3/29 of '08.
Okay.
And it's attached to the motion. It was basically a motion of, or a reply of opposition that Davis filed. So it was basically one. It goes to the court, and it basically gets kicked down again. And then now TAF tenant goes over to Rohrbar, who files paperwork, and you filed a motion which goes into great detail about the mail, and there was no forfeiture files with tenant.
Okay.
Do you remember that last motion they
I
filed?
honestly can't say.
It was the one that we showed you when we met with you in Fresno.
Okay, I'm sorry.
Yeah, I mean, I could probably bring it up, and I apologize because I'm trying to keep everything to the, as far as the discovery, because it's all base stamped, I'm trying to keep to the base stamp stuff.
Okay.
However, I don't know it by the base stamp stuff. It's all by file name for me.
Understandable.
So basically, what happened was, at the same time, and
I do vaguely remember that there was a time extension and there was a technicality with the other bonds, but then we were still looking for him. I can't say that I recall when it went to Warrenbau though. I don't.
It was after it progressed, and it was basically the third motion that got filed. Now, Davis wasn't involved in the last one. It was yourself and Warbar.
Okay.
And that was basically, you started out, and the first, this is the June 24th one. And I don't, and it's bait stamps 6185 and 6186.
Okay.
And I'll let you just kind of glance that over real quick.
Probably should have did this one. And that's what I was talking about with the signature, to properly prepare the certificate of mailing.
Okay, so do you specifically remember this declaration?
I don't specifically remember whether it was reading it it sounds familiar.
Okay.
Does it refresh your recollection?
I wouldn't say 100% no. I can't say that I know the situation, like, I could explain anything more to you.
Okay, well, I'll get to that. Okay, so basically from what you told us earlier, Mark Davis would basically come to you and say, hey, I need this signed.
And sometimes it wasn't even just a motion, it would just be the signature pages, and then he would put it all together in the office, then rush out to the
Okay,
courthouse.
so essentially you have no idea what you signed.
No.
Okay. Now, on 9/4/08, and I can probably bring it up on the computer and show you,
Okay.
but it's basically a more detailed copy of this.
Okay,
But
understood.
Mark Davis wasn't involved in that one. So I want to know who prepared that one from Rohrbar? Was that
His
Mark?
office did it.
Okay.
If Warrenball's, if we sent a motion to Warrenball, they would ask that we got, I know they had a list of stuff that we had to get when they did a motion, but they would want our office file, we would have to provide the courthouse file, and then that would all get overnighted to them. Then they would prepare the motion, call us with any questions, and then either fax or email, and then we would sign and file it from there.
Okay, so I know you probably can't give me a specific answer, but so generally Rohrbar would get the entire file?
Yeah, we would have to send them whatever information we had, and then I believe one of the things that they wanted was we would have to go and copy, not the whole court file, but they wanted all the minute orders.
Okay. Tammy Reyes was, I guess it's Tammy Reyes, huh? Tammy Reyes, AKA Tammy Beltran. There was, at the same time, there was other, at the same time they were doing, he was doing 10, and he also filed, I think it was 2, on the same date, they filed 2 motions for her, Tammy Reyes. And basically, in going through this, there was stuff, in reviewing it that basically said, we received the forfeiture letters. And that was like, let me try to find the specific entry.
Excuse me.
I apologize, I'm not as well organized as him.
You need some binders.
Yeah. Well, that's, like I said, that's what I was trying to avoid. Anyway, so basically, other than you, Mark, and AJ, who else handled motions?
It wasn't necessarily handling the motions, because like I said, the motions themselves were all handled off-site at Mark's residence.
Okay.
Mark did all the motions at his own residence. None of the motions were prepared on our computers or anything like that. So motions were prepared there. As far as like giving stuff to Mark, whoever happened to be working in the forfeiture department at that time would have the responsibility of copying files. I know Josephina had that responsibility for a little while. Raymond Renteria.
AA, Angelina.
Angelina Arellano, she worked in the forfeiture department.
So I talked to her that day of the search warrant.
Yes, she
Remember
was
in the
there as
office,
well.
and she
Mhm.
confirmed that she gave that file to Mark Davis, Gonzalo Lopez case.
Yes.
You were there, you heard that?
Yes, sir. And then I believe Aaron Rose worked in the forfeiture department for a little bit and did some copying. And those are the only names I know. But I know that, I mean, it could have been given to anybody at the time, you know, if it was busy and somebody wasn't doing something, you know, it was, hey, I need you to copy this file from Mark Davis and, you know, put it on the desk over.
But you also said Mark could come in at any time.
There were
And
problems.
basically kind of
Yes,
get
we
what
had-
he needed to get from whoever was there at
We
the
had
desk.
employee complaints of Mark coming in and just, you know, wanting to look through files. You know, he'd be on the in custody report and realize somebody's in custody and want to come to the office and look in their file and, you know, I mean, just being nosy. Mark was just too nosy for his own good. And unfortunately, I wasn't nosy enough to read what I needed to read, so. But yeah, so Mark definitely, I would say Mark had access. I mean, as long as there was somebody in the office, were they supposed to let him in and do stuff? Absolutely not, but, you know, Mark's an adult and, you know, he's pushy and, you know, if somebody's telling him to leave and he's, well, AJ knows, and, you know, you call AJ and he doesn't answer his phone, then, you know, you're not gonna question until we actually had a thing that, you know, Mark is not allowed in the office unless Janelle or AJ are here.
Right.
You know, and
Did you have that?
Huh?
Did you have that?
Yeah, we got to a point where he was coming in the evening and, copying stuff and taking stuff out of files, and we had to tell the evening employee, Mark's not allowed in the office. If Mark shows up, then you can call us, but otherwise he's not allowed in the office. He's not an employee.
Right.
He's not allowed in the files, he's not.
He didn't have a desk.
No,
He didn't
absolutely
have his
not.
name on the window by the door as you enter into the
He
business.
didn't have a computer,
He
and
didn't have a
like,
computer. He said the motions weren't written
Yeah, he
necessarily
didn't
at the
work in our
business.
office. The only thing that,
But he was supplied all reasonable and adequate and necessary paperwork for him to file these motions on behalf of the
absolutely,
company.
why would I want to hold anything from him? Yeah.
He had access to come in to get this information either directly from you or from AJ or anybody else there in the office staff. But then it got to be a point where he was nosing in
On stuff that he
files
didn't
and custody
need.
didn't need. And that's where the memorandum went out, hey,
Yeah.
BOL for Mark coming in at 2 o'clock in the morning. to go
And I mean,
through
I'm
some
sure you can
files.
see as through your investigation, the notes start to get more intense, like Mark has to sign when he takes the
Yes.
file. And Mark signed, you got the whole file. And
Yes.
Mark signed that you got this, and date and time.
Why was that progressive step taken here?
Because it was getting to the point where we were getting summary judgments, because Mark was saying that I didn't give him the file to do the time extension. And so when AJ's asking him, why are you doing a technicality motion when I asked you to do a time extension?
Right.
Which was the problem about 99% of the time, was we wanted the time extension. I mean, we had plenty of staff to look for these people. There was no reason
So
that-
there was already argumentation between AJ and Mark
Because Mark-
regarding the type of motions that he was filing
Yes,
in
Mark
these
was
cases.
taking it upon his own to find these technicalities and do these motions, and in reality, a lot of these, he had plenty of time to file a time extension.
Did
And
somebody tell Mark Davis about that?
Mark Davis was, as far as I know, Mark Davis was the one that brought it up to AJ and made that statement regarding the certificate of mailing not being signed. Therefore, if it wasn't signed, it's not
And
valid.
what did AJ say?
And AJ agreed with him because, Mark knows. I've done these motions for other people, and
So what
it's a
you're
fine
saying,
motion.
just briefly, and I don't mean to cut you off here,
No, it's okay.
but what you're saying is that when you're looking at the culpability of 3 people at the table, what you're saying is that it pretty much lies solely with Mark Davis.
When it comes to the motions, I would have to
With
say
Mark
so.
Davis. Did
Yeah.
you feel as if Mark Davis kind of used you,
This was Mark Davis's baby.
and even AJ had arguments with him as to, well, why did you look for a flaw when the flaw wasn't there? It should have been an extension of time so that I could have been able to do this. But it was more that, Mark, why did you do what you did?
And there was no reason to not trust him. He said, I did this motion, it's fine. I take it to Dean Wright, everything's great.
Let's talk about that really quickly, and that maybe ties into what you were talking about the success of the emotions, the fact that they were being mostly stipulated to without
Yeah,
any
I remember
opposition.
that part.
What was the setup with Dean Wright and County Council with Mark Davis?
As far as I know, like I said, Mark would bring it in for me to sign it, and then Mark would hand deliver it to whoever it needed to go to. And through what I've heard and said, he had quite the relationship. And
Let's go into that. What do you know about that relationship? What happened?
just the same stuff I'm sure you've read on the Modesto Beat about, the patent on the back and,
Yeah.
and whatever, that was.
That took place, so kind of the rubber
I would
stamping on.
I would assume so. I don't know. I just find it odd that I never had to file a motion. If you were in such a hurry, how come you didn't drop it off to me and send me to go file it?
Right.
Why was it that
He
everything had
wanted
to
to-
stay in your possession and you needed to take it to the court clerk and you needed to do what you needed to do? And half the times, I never even saw the motion.
So you found that odd?
Yeah, it seems
Because it didn't
strange to
happen
me.
with Bernstein
No,
and
because
Laurel.
Bernstein would send the motions to me, I would sign them and, go file it.
You were the ones that were filing those.
Yeah,
and-
but
Mark
these were Mark's creations, and he wanted to file them, and I don't know. I don't know if he took them to Dean Wright. I don't know if he went to the courthouse like everybody
But you
else
do know,
has.
you do know that Mark had personally gone to Dean Wright, and he other
From
than
what I
county
had heard,
council.
yeah. So
Did Mark tell you that,
no,
or?
not directly.
So how did you hear that?
Through the Modesto Bee and the hearsay of the meetings, all the babble, and that kind of stuff. The same gossip that pretty much started all this. So
But it's not gossip, it's
not all of it.
actually it has a factual basis,
Yeah,
right?
these motions this was Mark's thing, and nobody was going to question him, and Mark would argue it down with you. There are plenty of times when, like I said, he complained to AJ, Janelle's so stupid and she doesn't know what she's doing.
But you're not.
I'm not, no,
No.
I just wasn't the motion person.
Right.
And that's something else I find strange. How come, you never wanted to teach me? How come you never wanted to show me how these motions worked, or, have me help you produce these motions, or, which makes sense now because you don't want me reading. You don't want us knowing what's really going on. You just need our signature so that you can go take it to whoever you need to take it to and get it done.
Do you think I know what you're saying is you feel you got snookered by this guy.
Honestly, yes, I do.
Do you think AJ is in the same position?
I think with the motions, absolutely. I mean, you know, if AJ had known anything about motions and our business was doing so successful, why would we pay money out to somebody else to do it? You know, why wouldn't AJ have just taught me everything he knows? I mean, he's already stated that, you know, I'm his right hand.
Yeah.
You know, so AJ didn't know what was going on. And as far as the certificate of mailing, that's the guise that we were all under, was that if it wasn't signed, it was the certificate of mailing. And honestly, these motions just turned up out of the blue. This was nothing I'd ever heard of, I'd ever seen. In the beginning, it was all just time extensions or, you know, cut and dry things, you know, obvious things that you learn in insurance code. If they don't send it in 30 days, if it's not there, you know, there was no looking for these little details. It was
Right.
time extension, didn't get it, you know, bam, bam, no questions. And then all of a sudden there was this technicality that Mark came up with that it worked, and, you know, he filed these motions, they went through, it was fine, there was never any question, nobody ever said anything. So, I mean, why question it?
Yeah, yeah.
And then all of a sudden, you know, it just started rolling down like this isn't right.
And what happened when all of a sudden, and I'm not looking for a pat on the back, and I'm not going there, but all of a sudden, we turned that ship around. County Council and I worked diligently to try to correct some of these wrongs that were taking place, not just within AJ's, but with other bail bond businesses here in this county. And the fact that we were going to start looking at the information in these motions that were being filed, that County Council was no longer just going to rubber stamp or stipulate these things. We were actually going to research to see if there was a factual basis for these documents that were being filed. What then took place within the business when we started doing this?
Honestly, nothing changed because it never seemed odd that nobody ever, you know, questioned or needed more information. We just kind of assumed that that's how it worked, you know, that Mark knew what he was doing, and, you know, they stipulated to the motions.
But once we started opposing these motions, what then occurred within AJ's? What were you privy to? Was there, you know, why is there a new sheriff in town? Why is Miss Mims, you know, we got information that Miss Mims needs to be fired.
Well, there were questions as to what Miss Mims' motive was. Was it because she was really trying to, you know, figure out what was going on with these motions, or really trying to help the bail industry, or was it because
What do you
she
think?
was? To me, honestly, it really just seemed like she was trying to get money for the county, that these motions were a source of income, and she had made some statements that would lead me to believe that her big reason for arguing this was because it was money that she felt the county needed to make. And she had made a statement that pretty much said, you know,
But you're a smart lady, Janelle, and you understand that there has to be a liability on these bonds, right? For there to be an effectual bail bond and a whole bail bond business, and for the safety and the security of our community, there has to be some type of liability for there. When you bail somebody out of custody, there has to be some type of checks and balances there. We can't have people being bailed out for pennies on the dollar, and these people going out and committing a burglary in order to pay back a collection that's being told, or to pay back other bonds from previous cases because they continually be let out of jail day in, day out. You understand that, right? The whole process of that? That there has to be liability behind these bonds, and without that liability, we might as well just let everybody out of custody.
But I think that's something that maybe you don't understand, that regardless of how much money the defendant pays the company when they bail out, the owner of the company ultimately takes that responsibility with the surety.
Correct.
So if you bail out on a $100,000 bond and you only pay $1, that doesn't mean that AJ is any less responsible for the $100,000.
Correct.
So regardless of how much they're bailing out for, you know, I don't think that's relevant, you know, but then again, that's something in the bail industry that's never
But don't
really
you think
been
that
defined.
if he bailed somebody out for $1 and then he had to pay $100,000 on that bond, that there wouldn't be next time a little bit more scrutiny and a closer evaluation of this whole bail bond process for that particular individual?
It does,
It'll police itself, right?
and there were, and I'm sure you've seen in files, you know, there might be a bond for $25,000 where we only need one co-signer for one person, but because of another situation, we need 3 co-signers
Right.
for the same amount. You know, and there was a lot of that. There was a lot of due diligence to making sure that, you know, that these people went to court and they did what they did, and
Right.
that's why we were able to bail people out for such low down, because we had people that were making sure that they were home, we had people that were at the courthouse. We thought we were doing everything right. You know, we wanted to be like the ultimate service to the community.
Right.
And as far as I knew, I worked for a company that was really helping these people. You know, I mean, I went out of my way to take people to court, to, take people to the bank because they needed to do personal, take people
Right.
grocery shopping, things I don't even have to do with bail bonds. But that was the kind of business that.
Until you saw this.
Well, yeah.
And then you understood that really there was an undermotive or an undertow to what was actually going on, is that there was ultimately game playing being done with the court to
that's
thwart the
something.
process of what was actually supposed to take place with how the bail bond system is actually set up in this county. Then you understood, right?
Well, I mean, I to some extent, I can understand where all the confusion's coming from, and it's why did you do these motions, and what's going on with this, and how come this information's here. I mean, I can understand
You
why
get
you're
it.
questioning that. Yes, I
Okay.
do. But ultimately, nothing was being done with the intent of being unlawful. There was never any talk like, oh, we're gonna go behind and do this. There was never anything like that. If at any point in time I thought anything that was going on in that business was illegal, I would have left.
So you're saying if those conversations occurred, those were strictly up to Mark Davis and somebody else?
There was nothing ever said in front of me that led me to believe that anything that was being done was illegal, or I would have been gone. And certainly after the first raid, I mean, there was a lot of looking around, and still at that point, there was nothing that I could see that I in this business was doing that was incorrect.
What happened? What happened after that first raid? You said
We tried to keep
you had
going.
regrouping, and
We
what
tried
was
to keep
said?
going. We had to copy files, and business had to go on. That's our life. I mean, now we've all lost homes, and
What took place? What took place behind the scenes, Ms. Janelle, regarding that first raid? What did AJ say? Did he have an employee get together and he stood up front and said, "Hey, listen, the FBI just came in and raided our business, looking for particular files. We need to make sure that we're a little closer."
we had
reviewing."
no idea what was going on. I'll be honestly, nobody understood what was going on. There was talk like, oh, does it have to do with David Nelson? Does it have to do with one certain employee that works here? Is it about AJ? What's going on? And then the federal subpoena started coming down, and then even still, it was not clear. There was never cut clear, like, this is what you're doing wrong, and let's look into that and fix it. It was just kind of like, first was the.
But there was changes after that.
As far
As information in the bond trackers, there was changes with the files, there was changes with the notes that were being made in the files, things were disappearing that were once.
Well, not so much that, but there was changes in the business practice after that, correct?
After the first raid, the business slowed down a lot just because we didn't have a lot of our files. I mean, there was a lot of time devoted to
Right.
rebuilding.
But I'm getting more into the second part.
bonds?
Well, no, I'm getting more into the second part of what you're charged with, which is the conspiracy for extortion. After the first raid, did people continue to be brought in handcuffs and handcuffed to weight equipment and basically made for money?
You've seen the discovery in this case.
Yes.
You know what people have said regarding being brought in,
Uh-huh.
being swept for dollars or whatever you want to use the terminology, that people were being brought, handcuffed in. Either you were there during particular times or you weren't. Sometimes it was after hours, sometimes it was on weekends. Maybe you're not privy to some, but some you are, according to some of these people in their statements. What John is saying is that after those search warrants, business started changing. People were no longer being brought in, and the manner of business changed as to how they were dealing with collections. And he's asking you what took place, why the change, and who gave the direction as to change the way that business was being done.
I honestly can't remember a drastic change, and I can't tell you that nobody was brought back to the office after the raid. I honestly can't remember, but I know that.
Do you remember the form that came afterwards that said everyone started signing that said if you are there was a form that basically they were signing away their rights to be brought in or arrested.
There was a form that was produced prior to the raid because there was issues, with David, and people were complaining about David showing up at their house, or we were concerned that by giving people rides to court and stuff, they could say that, we were forcing them or whatever. So there was a form that was produced that pretty much just said that if we're giving you a ride or we're picking up or you're getting in the vehicle with us, that you're not doing it under duress.
Okay.
That's
the form.
You can say no, and that was pretty much the ride because we didn't want there to be an issue with people saying, oh, I got kidnapped. Or
Because you knew that
Because
there was
I
talk
knew had
of-
they turned their story around, then it
Right.
could get in trouble. And I
And
mean,
you
it
knew
could-
that we were out interviewing people and they were telling us that information.
I know that there were complaints. I know there was a lot of issues with, we got stopped getting paid a lot because there was a lot of complaints where, the DAs were out at our house and, they say we don't have to pay you guys or you're not in business or, I'm sure the same things that happen every time something to this extent happens. But yeah, it wasn't like we had a meeting and AJ sat down and said, we're not doing this, or do this
Then how was
different,
that
do
passed? Was it passed via note? Was it
I
an
think-
email message to all
I
employees?
honestly, I
Or
don't think that there was ever anything that AJ said that we're doing things differently. It was just a scramble to scrape up whatever business we had left. And of course,
what
we
did you
did
think
it-
about the whole collection deal that was taking place at the business between the guys that were going out collecting up these individuals, either from
As
the
far
court or
as
from
I
the house
knew-
and bring them brought back into
As
the
far as I knew, the
AJs?
people that were getting picked up from their houses were because they weren't at their address, or they weren't answering their phone, or
Right.
we couldn't contact them. And the reason that they were being brought back in handcuffs was because a lot of these people were dangerous to
Okay.
the staff.
But you bailed them out.
Well, yes, of course, but
Okay.
then after you become a flight risk, or you're not answering your phone, or you're being sketchy, it's different than the day you get released from jail and you come see us from, 3 months later when we can't contact you and, you're coming in and, just for example, you're strung out or something, to
And that would
that
be,
extent.
and that would be certainly a platform to be wanting to have these discussions with these individuals,
And at that
right?
point, they would come in and if everything was fine, the handcuffs would be removed, they would discuss what the situation was, whether it be, you're not at your address, you're
Right.
not holding up your contractual liabilities,
Right.
what do you want to do?
But also, with your statement to the U.S. Attorney's Office, and I think you actually said, they brought in clients who were on failure to appear status. Clients were apprehended, brought back to AJ's office to decide what to do. Clients were let go if they could pay for a reinstatement letter and get caught up on their payments that they owed AJ. The reinstatement letter would cost AJ $50. AJ would charge $225 for a reinstatement letter. You remember making that statement
Yes,
that
I do, that's true.
they would come in and they would renegotiate the payment of what they've missed or getting reinstatement letters.
Yeah, it's
That
basically a renegotiation.
Why
of the
didn't they go to
contract.
jail, Janelle?
Because
Why did they? You are a failure to appear. The court is looking for you. You have a warrant for your arrest. The judge has signed an order demanding you to be brought forthwith to law enforcement or to the county jail. Why aren't they going?
Because reinstatement is an option that a bail bondsman has, and that is an option that we give our clients because not all clients.
But they're brought in handcuffs, Janelle. Why don't they
But
just go
not
straight
every-
to the jail?
I can't answer that. I just know
Who
that
can?
reinstatement.
Who can answer that, Janelle? The team that brought these guys in? You as the office manager or AJ as the business owner?
I would say you'd have to ask AJ that question
Okay.
ultimately.
So the direction would come from AJ.
Yes, because, and I know that our motto was, why do you want to take people back to jail? Because if you take people back to jail,
Ruins your reputation,
then it
right?
ruins the reputation. So if we can help these people by reinstating, then why not?
And it helps you because you can sweat them for dollars, right? They're getting
I
tied to
don't-
weight benches and, Janelle, you witnessed some of this.
Yeah, but it wasn't necessarily for money. Yes, there were times.
But you
when-
said,
Uh-huh.
you told the U.S. Attorney right here in this statement, if they could pay. What about if they couldn't?
Then there were times when we contracted, we arranged new payment plans and they were let go, and there were times when they went back to jail.
How many times do you think these people actually went from your place to jail?
Excuse me.
God bless you, God bless you.
Sorry.
Janelle, to your knowledge, how many times do you think these individuals that were brought back in handcuffs against their will were sweated down at AJ's for additional money to be brought back and they couldn't come up with it? How many times did those individuals go to jail? And I can look at the court custody
I know, that's
records
what
and see
I'm
how many times these people were surrendered by AJ
I
bail
would
bonds.
say less
And
than more.
I tell you that it's very few, if any.
There weren't as many surrenders as renegotiations. That's a true
Why?
statement. Just because that's the business we were in. We renegotiated contracts and money was a part of the contract. It wasn't necessarily just, I want this money and that's it. It was new addresses, new phone numbers. In some instances, it was new co-signers. But, yes, money was a part of it. to
I don't
some
know how
extent.
much knowledge Mr. Hankins has about this, but when I first started looking at this investigation and started looking into this, it was almost like this is like a modern day mob setting. Where the wolf was in policing the sheep within the sheep there in the hen house, and everything was kind of running awry, and these people were, not necessarily you, Janelle, but other people within this industry were doing what they pleased.
And that's a lot of the problem.
And you don't think the community is at risk when this type of stuff happens?
But it's not, but I think that you're getting the wrong picture of what was going on with these people. They weren't all brought in and yelled at or treated horribly. They were sitting in front of desk and
But there was a progression.
Does the name Benjamin Campbell mean anything to you?
That name does sound familiar, but
Benjamin Campbell was taken downstairs and handcuffed to a pole.
that is something that I had heard about but was not privy to. Because believe me, if I had been privy to that,
What would you have done?
I'd have a problem with that. Probably would have said something to somebody because, that doesn't.
But you knew it took place.
Could you relate the story, please?
But I didn't.
Benjamin Campbell was brought in, basically told, come up with money and we'll let you go. He couldn't come up with money. So they decided to take him downstairs, handcuff him to a pole. They turned out the lights and came back, according to him, several hours later.
They not being me.
Right. No, you were never
Okay.
implemented
Just
as
to be-
being
just
part of
to
that.
be
I was
clear.
just gonna ask you, were you working that day?
No, I wasn't working that day. That was, I believe, if I'm correct, that's something, I want to say, if I'm correct, that's something that happened before I was there even? I'm not even sure. I remember hearing about it, but never knowing if
What
it
did
was
you hear,
necessarily
Janelle?
true. I had heard that an agent had handcuffed one of their clients down there and,
Well, that agent being AJ.
oh, yeah, I didn't know. I didn't hear it was AJ. That's not the story.
Who told you that, Janelle?
I think it was just like talk amongst the agents in our office, and I thought it was one of the agents that did it, but
Why was it talk? Was this something to build a reputation for a particular person within the business?
we had agents
or-
that were doing whatever, excuse my language, but were doing whatever the hell they wanted.
Right, and that's
They,
what,
they really were. I mean, anytime they could, get around somebody being there and seeing what they were doing it, which is hence the reason that we had cameras installed, at
Right.
one point. It was getting to be ridiculous, these agents were bringing people in after hours and, doing whatever they wanted with their clients, and AJ knew at that point, what's going on? I can't have these guys doing it. And there were multiple meetings where you can't do this and you can't do this. And these guys were just gonna do whatever they wanted, as long as they could get away
I
with
think
it.
AJ was doing his very best to try to contain and regulate these guys.
I really honestly do. I think that, there were a lot of procedural manuals and memos and things that went out and talking to these guys, and there were reprimands and, statements that were signed that, you realize you did this, you're not gonna do this again.
And AJ told us about that. And he said that, specifically when he was talking about David Nelson, he said, I understood what was taking place. I didn't condone it. I didn't appreciate it. I didn't want it occurring. However, David Nelson was very profitable for the business. So there was lines being drawn between, I didn't want it happening. I didn't want this occurring. But yet, at the same time, I'm afraid to drop the hammer because, number one, if I drop the hammer on particular agents or people that are generating a large portion of the business, it cuts away from my profits. It cuts away from my reputation and like what you said, we wanted to be the ultimate. He did. He wanted to be the ultimate. And disciplining these people that were bringing forth a lot of customers and a lot of revenue was not going to be profitable for him.
Well, they were disciplined, but
But nothing ever happened. This was like some internal discipline that he's
I mean-
meeting out, that he spank them?
No.
What did he do, Janelle?
No,
Tell
they
me.
were written up. The most you can do when you work for a business, I guess. They're not your kids. You don't spank
But
them. You
he
don't
certainly
ground
didn't
them.
report him to law enforcement, right?
No, I guess not.
He certainly didn't bring him down and, or grab Mr. Hankins or some of the other lawyers in town and say, hey, I need some help drafting some legal documents so that I'm not liable for what these guys are doing. And I need to do something to put together some type
But
of
I do
performance
think-
manual.
I think part of it though is that we're under the understanding that bail agents are responsible for themselves.
There's policing supposed to be within
My personal understanding was when I went through bail school is that bail agents are responsible for yourself. You're a bail agent. You can go and start your own business, be responsible for your own business. Or you be a solicitor where you work for somebody and you're their employee. So I really think that AJ thought that these people are not individuals,
He would
are
cooperate
independent
and-
contractors. So what they do,
Well,
regardless.
that's not really the case though, because AJ is, I'll tell you from my point of view, AJ is one of the few agencies in the state of California that uses solicitors. And a solicitor can only work for one specific person. Can't go out and, like, say if you were a solicitor, you could only work for AJ. You couldn't work, you couldn't change jobs. You couldn't go out and start your own business.
But we only started doing them as solicitors later in the business because AJ was paying for people to come in and get their bail agent license.
Okay,
So
granted
that's-
that, but when we came in to start looking at it, there was quite a few solicitors.
And those were the people that had gotten licensed in the most recently, because
Right.
everybody who had gotten licensed in the beginning was
Davis,
being licensed as a
Nelson,
bail
yourself,
agent. Yes,
You were all bail agents, not solicitors.
Yes,
Okay.
correct.
So you could leave and go other places.
yes, correct.
Oh, you want to take a break? Okay.
Yeah.
All right. We'll take a quick break. Is that okay, John? We're
Yeah, no, that's fine.
asking Janelle some
Till
questions.
11:30.
Okay, there's a bathroom at the end of the hallway, and there's a water faucet right there, where I can get some bottled water if you need it.
Just kind of as estimate, how much longer do you think you're gonna kind of let my mom know with the baby situation?
Yeah, probably half hour.
Okay, no problem, that's
Thank you,
fine.
Janelle,
No
appreciate
problem.
that.
Thank you.